The assets, the income, the things that come in during a marriage are going to be presumed to belong to the community, belong to both the husband and the wife. There are some notable exceptions to that rule. Like a personal injury settlement for pain and suffering. That's not going to be community property. It's going to be separate property. Gift or an inheritance, something like that. It's very rarely going to be community property. It's going to be separate property most of the time. Obviously, everything you came to the marriage with is going to be separate property. Although, one of the issues you'll see is if you commingle your separate property and your community property, well, guess what? Now it's all presumed to be community property. And you have to establish through clear and convincing evidence, which is the standard right below beyond reasonable doubt, that something is separate property rather than community property. Sometimes it's easy to do if it's something you clearly came to the marriage with, but one of the things you see most often that people are confused by is they think that because something's in the husband or wife's name, that necessarily means, well, it's in their name, so it's theirs. That's not true. That's just simply not true. You have to look a lot deeper sometimes in order to really determine whether or not it's going to be community property or separate property.